481 relief is state aid, and therefore it has to comply with EU directives in this area. Okay? So the allegation is not about, this can't be, you can't negotiate away your rights. Right? You can't do that. You're not allowed. So I want you to understand the point I'm making. You cannot negotiate away your rights. No group who claims to represent the industry can negotiate away your rights. What Equity and the Film Workers Association, and indeed the writer who I quoted briefly made the same points. I'll send you some of the correspondence. What they say is their rights, the law is not being complied with. Now that's not an allegation, right? That is something you have to investigate if there's a possibility that it is even true. That the law is not being complied with and that EU directives you are required to comply with in providing this state aid is not being complied with. And you see, the point about the DAC is this. Everything survives the DAC except the employment relationship. That's the only thing. That's the evidence we've got from the producers, not an allegation. They've admitted it. They say no employment relationship can survive the DAC. But the Fixed Term Workers Directive and Act requires that the employment relationship goes beyond the DAC. That's the point of it. It is to protect people who are in episodic employment relationships. And the other thing that does survive the DAC is the intellectual property. But it accrues to the producer company, not to the people who own it. That is in breach of the Copyright Directive. You cannot finance a structure which is being used to break the law.
Structures are being put in place that are leading to the breaking of the law in relation to the claiming of state aid and also in relation to the use of taxpayers' money. If you've evidence in relation to this, or the people who are raising this but you have evidence, they should report it to either to the Revenue Commissioner or to the Health and Safety Authority, or raise the matter directly themselves with whatever the relevant body is. We oversee the implementation of the Section 481. We published a thorough overview of the operation of the scheme, I think only earlier in the year, in September. And if you believe that the law is being broken with regard to it, you have a duty to present that evidence in a very specific way to the agencies that are involved in overseeing the law, as opposed to making broad allegations here this evening about a sector that I believe, from the evidence and reports that I have, is making progress in dealing with issues about workers' rights, living standards and good pay. You made the claim here that you can't negotiate away rights. I'm not asking that anybody does. And what I'm saying is that collective agreements and engagement through the Workplace Relations Commission is the way in which these matters can be tackled. And a classic example of this is the issue that you are referring to in relation to IP and intellectual property. If you believe the balance is right regarding the gains from intellectual property between the producer and between those working on individual productions, the way in which progress can be made in those matters and engagement and negotiation is with the Department of Enterprise, Trade and Employment, but I imagine far more likely the Workplace Relations Commission in relation to the contracts that are in place to oversee the allocation of profit and revenue. Or the allocation of profit, I should say.
This is complicated, okay? And it takes a while to get your head around it. But the CEO of Screen Producers Ireland, who struck the agreement you're talking about, right, gave the following evidence to the WRC in a case taken by a film crew worker. I will give evidence before the court that there is no possible basis, having due regard to the realities of the sector, on which a relationship of employment can be said to have existed between the parties hereto. This is on the basis of the clearly established industry norms and practices governing working arrangements in this sector, including the operation of Section 481 relief. Do you understand what she's saying there? She's saying there cannot be a relationship between the film producer company and the worker who works on the film because of the structure of Section 4. That's what she said. And you're giving these people money. She's saying, my members cannot have employees because of the way the industry is structured. That's her saying it. And yet at the same time, you continue to give them the money for quality employment and training, and you take them seriously when they say they're striking an employment between employers and employees when they say they can have no employees. Do you not understand what's being said to you?
I understand completely what you're making allegations here, though, in relation to the operation
I am saying
of a
this is the structure of the relief
investigation.
I'm asking you to go to Europe and ask them for an adjudication on this. That's a reasonable thing to ask, isn't it? That's not a reasonable thing to ask. How is that not a reasonable thing to ask? Seriously, like. If there's a question mark, have we not been down this road before with compliance or non-compliance with EU directives, where people had to go all the way to flipping European courts in order to get adjudications?